Good day everyone. Today, I will discuss what I learned on our past discussion on criminal justice system. So, criminal justice system, in short CJS, is based on what I learned is the machinery of the state of government which enforces the rules of conduct necessary to protect life and property and maintain peace and order. It is the machinery which society uses in the prevention and control of crime. The process is the totality of activity or activities of the law enforcer, prosecutor, defense lawyer, judges, and correctional personnel, as well as those of the mobilized community in the crime prevention and control. Criminal justice system came from the word crime and justice. Crime is any offense against a public law. This word, in its most general sense, comprehends all offenses, but in its limited sense, it is confined to felony. Felony is punishable by revised penal code, and justice is defined as rendering to others what is due to them. It means fairness or moral rightness. The main purpose of CJS or criminal justice system is to process individuals who have been accused of criminal activities, to carry on the processing procedure, and to accomplish the desired purpose. We simply follow the pattern of criminal justice system. As an introduction to Philippine criminal justice system, I also learned the 5 pillars of CJS, which consists of law enforcement pillars, prosecution pillars, courts pillar, correction pillars, and community pillar. Law enforcement pillar, which is the first pillar of criminal justice system, their work consists in the prevention and controls of crime, enforcement of laws, and effects the arrest of offenders, including the conduct of lawful searches and seizures to gather necessary evidences so that the complaint may be filed with the prosecutor's office. So dito sa law enforcement pillar, apprehended by the police or agency like NBI, narcotic groups, and etc. Sila yung naghahanap ng sufficient ground para masustain yung complaint against the suspect. By the way, complaint is a statement where you were charging a person with an offense. Nirereklamo mo yung isang tao kasi meron siyang ginawang masama sa'yo or may nakita kang ginawa niya na mali sa ibang tao. Suspect naman is yung tao na reklamo mo dun sa law enforcement agency, sa mga police. So, back tayo sa topic. Prosecution pillar is the second pillar of criminal justice system, which refers to the agency and other offices under the Justice Department authorized by the government to represent the state in the prosecution of criminal cases before the court of law. Prosecution may refer to the agency responsible in presenting the government's position in criminal cases and evaluating pieces of evidence presented by the law enforcement. Moreover, prosecution is the legal process, methods by which an accusation is brought to the court or any judicial or quasi-judicial body for proper adjudication or arbitration. Karagdagan pa sa mga natutunan ko sa lesson namin, ang function ng prosecution ay sila yung nagfa-file ng corresponding criminal complaints or information in the proper courts on the basis of their evaluation on their proofs at hand. And also, they prosecute all alleged offenders in court in the name of the people of the Philippines. Ini-evaluate nila yung police findings referred to them or other complaints filed directly with them by individual person or yung tinatawag nating complainant. Dito sa prosecution pillar, ang prosecutor ang nagse-serve as a lawyer of the government in criminal cases and automatically considered an officer of the court, at the same time a member of Department of Justice or DOJ, which is under the executive branch of the government, thus independent from judiciary. Sa prosecution pillar, yung mga prosecutor, sila yung nag-i-investigate kung tama ba yung ginawang process ng pag-arrest dun sa suspect, o tama ba yung mga ginawa nila, appropriate ba yung pag-arrest nila. Sila, dun sa prosecution pillar, sila yung naghahanap ng probable cause para i-sustain yung complaint na i-file ni complainant sa prosecution. To make it clear, probable cause is the standard by which police authorities have reason to obtain a warrant for the arrest of the suspect, criminal, or issuing of the search warrant. Moreover, as basis in charging or prosecuting a person for an offense, probable cause is the existence of such facts and circumstances as would excite the belief in a reasonable mind, acting on the facts within the knowledge of the prosecutor, that the person charged was guilty of the crime for which he was prosecuted. While, as a ground for an arrest or issuance of warrant of arrest, probable cause is such facts and circumstances which would lead reasonably discreet and prudent man to believe that an offense has been committed by the person sought to be arrested. While, as a protection against false prosecution and arrest, probable cause is the knowledge of facts, actual or apparent, is strong enough to justify a reason man in the belief that he has lawful grounds for arresting the accused. In this prosecution pillar, I remember that we have two types of investigation. The first one is the preliminary investigation, and the second one is the inquest proceeding. In preliminary investigation, it is the proceeding for the purpose of determining whether there is a sufficient ground to engender a well-founded belief that a crime has been committed and that the respondent is probably guilty thereof, and should be held for trial. A preliminary investigation is required to be conducted before the filing of the complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to the fine. On the other hand, inquest proceeding is an informal and summary investigation conducted by a public prosecutor in a criminal cases involving person arrested and detained without the benefit of warrant of arrest, or what we call the warrantless arrest, issued by the court for the purpose of determining whether or not the said person or the suspect should remain under the custody and corresponding charge in court. So, we discussed the law enforcement pillar and prosecution pillar. Now, we must move on court pillar. The court pillar, or the third pillar of the criminal justice system, is the centerpiece of the criminal justice system. Moreover, based on what I remembered on our discussion, court pillar is the centerpiece of criminal justice system. Judiciary as the third pillar of criminal justice system, judiciary is also what we call court, is looked upon as the final arbiter of justice, the front line defender of democracy, freedom, and dignity, the only institution capable of identifying and maintaining the proper balance between conflicting rights of individuals and of the state and society. The agencies and the offices comprising the Philippine criminal justice system in court was Supreme Court, Court of Appeals, Sandigan Bayan, Regional Trial Court, Metropolitan Trial Court, Municipal Circuit Trial Court, and Court of Tax Appeals. In identifying the Supreme Court, Um, it is the highest court of the land, composed of a Chief Justice and 14 associate justices. It has appellate jurisdiction over the cases decided by the court of appeal, and has the power of judicial review. It is also the last resort. The court of last resort is also known as the court of last resort. The second one is the court of appeals. The court of appeals, based on what I remember, it is headed by presiding justice and composed of 68 associate justices. It has appellate jurisdiction over cases decided by regional trial court. It reviews not only the decisions and orders of RTC nationwide, but also those of Court of Tax Appeal. The second one is the RTC, or the Regional Trial Courts. It is presided by regional judge. It has general jurisdiction over criminal cases and has jurisdiction over offenses punishable with imprisonment of 6 years and 1 day and over. It has appellate jurisdiction over cases decided by MTCC, MTC, MCTC, and METC. In court, we have 5 criminal proceeding. Arraignment is the stage of criminal proceedings. The object is to determine the identity of the accused. Then, the court read to him the nature of the charge against him in the language or dialect that he or she must understand. And then, it is required him to enter a plea or of guilty or not guilty. To make it clear, plea is the response of the accused when asked whether he is guilty of the offense charged by him or her, o yung chinarge sa kanya nung complainant. The second stage is the pre-trial stage. Sa pre-trial stage, a conference, ang pre-trial is a conference called by a judge that requires the presence of both prosecution and the accused before the beginning of the trial. It is mandatory in all criminal cases. Mandatory po siya, based siya dun sa pagkakaalam ko, mandatory siya. Dito sa pre-trial, merong tinatawag na plea bargaining. Ang plea bargaining is the process whereby the accused or the offender or the offended party and the prosecution work out mutually satisfactory disposition of the case subject to the court approval. The third stage is trial. Trial is the examination before a competent tribunal according to the laws of the land. Dito dinadala yung mga evidences ng dalawang party. Kunwari, may kasalanan ka. Dito sa trial, ipinapakita yung mga katibayan na gumawa siya ng ganitong krimen, or para naman dun sa suspect, parang pinagtatanggol niya yung sarili niya through pagpapakita ng mga evidence niya na siya ay not guilty. And the fourth stage is judgment. Judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged by him or her. After ng judgment, binibigyan ang suspect or yung offender of the law ng appeal. Ang appeal is the evaluation by the aggrieved party. Aggrieved party is the accused of any decisions ordered or award of a lower body to a higher body by means of a document which includes the assignment of errors, memorandum of arguments in support, and the reliefs prayed for. The next one is the correction pillar. Ito yung branch of the administration of criminal justice charged with sila yung responsible for the custody, supervision, and rehabilitation of the convicted offender or the criminal. So, dito napapasok yung parole at probation. Sa parole, siya yung temporary released ng mga siya yung temporary release from imprisonment where they rendered their minimum penalty. Yung na-render nila yung minimum penalty nila doon sa loob ng jail. Samantalang ang probation naman ay nag-a-apply ka for probation. Which is, kapag naaprubahan yung probation mo, doon na papasok yung court. At doon, sa court, doon na papasok yung community pillar. Sa community pillar, kapag ikaw ay released from imprisonment, yung minomonitor ka nila kung ikaw ba ay nagiging mabuting mamamayan na sa iyong community. At kung may napansin sila na parang gumawa ka ulit ng panibagong case, doon ulit iikot yung criminal justice system. Mag-uumpisa na naman tayo sa law enforcement, then sunod is prosecution, followed by court, correction, then kung magiging mabuti ka ulit, pupunta ka na ulit sa community. At yun lamang po yung mga natutunan ko at tumatak sa isip ko nung tayo ay nagdi-discuss sa criminal justice system or CJS. Thank you.